everyone. Those were the headlines, and let's now take a look at our top story on South Central, and this is related to India's crypto landscape, which might have just crossed a crucial legal threshold. In fact, in a ruling involving wazirx and in a first, the Madras High Court has ruled that the cryptocurrency qualifies as property under Indian law. The case stemmed from an investor's petition whose XRP tokens, which is again a type of cryptocurrency, were frozen on wazirx, which is again a cryptocurrency trading platform, and this after a cyber attack. In fact, the court has held that the crypto can be owned, enjoyed, and held in trusts like other assets, effectively granting digital investors legal protection and enforceable rights. But how significant is this ruling, and what does it really mean for investors of crypto? Well, let's try and decode some of those points with Shravanth Shanker. He's an advocate of the Supreme Court of India, and he is joining us live on the show. Thank you very much, Shravanth, for taking the time out and speaking to us here on ET Now. Now, of course, we'll come to the implications of this ruling, but let's first address how crucial is this, and what exactly is this ruling all about? What does it really change as far as the crypto landscape in the country is concerned?
Thank you so much for having me on your show, Sumita. This ruling is very significant, keeping in mind two important aspects. First of all, we're going to the background. There is no global treaty or convention with respect to crypto till date. And India has incorporated some of the Financial Action Task Force, FATF, the recommendations. However, only in 2022, we have included crypto as an taxable income, and 30% of flat tax has been applied on it with 1% TDS. And like you know, the cryptocurrency and regulation of official digital currency bill, which is also called the coins bill, which is still pending in the parliament. Now, coming to this judgment, it's very important because the High Court of Madras has recognized cryptocurrency to be an asset while giving security to the petitioner to have protected their assets which were frozen by the platform.
Right. But Shravanth, what are the implications of this ruling, especially if we talk about, the investor community or, of course, the crypto sector as a whole, which has been highly and heavily regulated?
Yes, then I can suggest 5 of them. One being the fiduciary duty of the host crypto exchange platform is heightened, and the users are secured as legal owners of their proprietary rights. Second, investors who are merely users of platform are now legal owners with proprietary rights which can be contested in a court of law, including injunctions, trust claims, restitution, insolvency protection, civil suits, and criminal proceedings. 3. Judicial recognition has now outpaced legislative framework. Therefore, there is an urgency for comprehensive regulation. 4. Further, the customer protection framework may also need to be looked up to. And lastly, the property status which has been legitimized, the existing tax regime of 30% tax and 1% TDS. Therefore, this judgment strengthens the government's position to enforce mandatory disclosure.
Right, so you're essentially speaking about mandatory disclosure, and of course, while crypto is, the Madras High Court did rule that crypto can be recognized as a property, but Shravanth, you do have to understand that crypto is still not legal tender in India, so how does that ruling fit into this reality that the country faces?
So although crypto is not legal tender in India, in fact, I can think of only one country, El Salvador, where it is legal tender. Even if you go to Dubai, there is Virtual Assets Regulatory Authority, which regulates use of crypto in Dubai. So crypto is not a reality of tomorrow, which is a reality of today. So when having government been very well aware that crypto has been traded and tax implication has been brought in, and in fact, government is proposing to create its own official cryptocurrency to be issued by the RBI through the coins bill, which is in the parliament. So it has although it is not a legal tender, government has acknowledged that this has been traded upon, because like you know, Sumita, crypto can be itself traded like silver and gold. So therefore, government very well knows that people are earning profits. Of course, there are a lot of hesitations or risk involved with respect to money laundering, terror financing, illegal trade, etc. But government knows that it is the reality of today with respect to taxation and with respect to protection of rights of the consumers who have purchased the cryptocurrency, especially the fiduciary responsibility of the host, crypto exchange platforms has been brought up. So that is the significance of it, as I understand.
Right, but what are the additional regulatory risks that remain?
Regulatory risks that remain, first being when crypto is mined, the biggest regulatory risk right now today is that crypto can be purchased anonymously. You did not have to disclose your official documents or personal data, and all of this has been regulated through the blockchain, which is the digital ledger, which actually tells you the provenance of the cryptocurrency. So therefore, the risk of double spending or counterfeiting is zero. So when the entire regulator is with the host platform, for the government to be able to enforce guidelines which are equivalent to what you put for a legal tender is something the government is should be looking into. And also, of course, the consumer specific guidelines, because people who purchase crypto after having it mined and trading it, they have several risks. Say, for example, in this case, wazirx platform had two kind of cryptocurrencies, xrp crypto and erc20 crypto, and there has been a cyber attack due to which this petitioner's cryptocurrency was frozen. Then this petitioner goes under Section 9 of Arbitration Act to Chennai High Court, the Madras High Court, and seeks protection of her cryptocurrency so that the host platform does not socialize the losses, in the sense that they don't take the losses and give away to other people who have actually suffered a loss, while this petitioner did not suffer a loss. And what is very interesting here in this case is they have referred to two judgments of the Supreme Court of 1969 and 1995, interestingly saying that everything that has exchangeable value or which goes to make up wealth or estate or status constitutes asset. And further, using another judgment, reading into Article 300A of the Constitution to define property. So, going into the definition of property, say your immovable properties are regulated by A, taxation, two, registration,
Right.
three, with respect to other GST implications. So, with respect to bringing in uh, direct tax has been done. Indirect tax could be something they may explore.
Okay. Right. Okay, okay, and we'll have to see, what else does the Indian government explore. But specifically coming back to this particular ruling, Shravanth, what are the implications for crypto holdings and foreign exchanges or wallets when held by an Indian resident outside of India?
So this particular judgment only deals with cryptocurrency which has been purchased within India, does not go into the international ambit. Although what may interest you, if I may read three sentences from the judgment which are very relevant for our understanding. The court finally summarizes the entire ambit of this question while granting relief to the petitioner. I must tell you that the court says, I quote, there can be no doubt that cryptocurrency is a property. It is not a tangible property, nor is it a currency. However, it is a property which is capable of being enjoyed and possessed in beneficial form. It is capable of being held in trust. So, going into this definition, they have put themselves into the confines of the Indian jurisprudence only, while dealing with an arbitration which is actually seated in Singapore. So, whoever purchases cryptocurrency on wazirx platform, they are bound by an arbitration contract where the seat of arbitration will be Singapore. Although the value of the cryptocurrency was about 9.5 lakh Indian rupees only, the Madras High Court has gone in to say that yes, of course, there is clear jurisprudence, even if the seat is outside, for interim relief because cause of action has arisen in India. You can go to an Indian court to secure your property. But the court has, while having dealing with arbitration law on the international front, has confined itself to the domestic laws only. Although I must tell you, Sumita, there is one UK judgment of the House of Lords where four four
Right,
qualifications of an asset have been dealt with, but it
right,
does not really help us on the international front
right,
of regulation.
right. Right, Shravanth, let me also ask you, since crypto is legally now, according to what the judgment essentially says, that it is property, does that mean that a holder has stronger recourse in cases of loss, theft, or freezing of assets?
Absolutely. Here, what you see, Sumita, Interestingly, arbitration allows you to take what you call a 39(1) and 2 interim relief in a civil suit after filing the suit. In arbitration, you can do the reverse. You can actually protect your property and then go to claim it, claim your full rights on it. So here, what the court has actually acknowledged the right because it's a taxable asset. Once you transact, the profits are taxable by 30%, has given them relief. So coming there, you have now right to move courts for injunctions, trust claims, restitution, insolvency protection, civil suits, and maybe criminal proceedings. Like say cyber attacks, you can lose your cryptocurrency like in this platform. So probably investigating agencies can also take over from here, considering this to be uh, a valuable asset. So will it be coming into forging legal valuable security or not is up to the courts to decide next. But that is something what will be very interesting to look at.
Absolutely. And that is something that we'll also keep a close watch on. But Shravanth, how might this ruling influence upcoming regulation of virtual digital assets or VDAs by the government or regulatory bodies, for instance, the Reserve Bank of India or the Securities and Exchange Board of India?
I firmly believe it will have a very positive impact on it. It only strengthens the direction in which all the regulatory bodies and the government is going into. Because once you protect a citizen of their rights on a particular asset which they have used a valid legal tender to purchase it. So to mine a crypto, uh, you don't need to put valid legal tender, but to purchase a cryptocurrency even in a form of an NFT, you need to put valid legal tender. So when I'm putting currency to buy a crypto, then I have as much right on the crypto, so much as I would have on, say, a gold or a silver, or say any stock market equity which I would purchase. So it will have a similar impact on it.
Right, but Shravanth, one final question before we essentially let you go, because experts have suggested that implications are not absolute and it could face an appeal. So, on what grounds will an appeal be sought?
So probably, see, I completely agree because Section 9 order is an appealable order and it can be taken all the way to the Supreme Court. And this is the first time this particular issue of law has been answered. So to going to defining and giving a legal sanctity to cryptocurrency in a court of law, this has been the first time. Till now, the question has been what we say in legal words, res integra. So going forward, for someone to challenge this in the sense that this being an asset would be limited to the tangibility and non-tangibility of it, and also how much mobility this particular asset has. Say, for example, if you want to buy a car or a property in India, you can't use cryptocurrency to purchase anything. It is an asset, it is non tangible, but again, it is not transactionable. So, in the sense, going into the actual definition to give it the same status as you would have for a car or a property or even say currency, it may not fit into the definition completely. So on these grounds, probably there is a possibility for a court to interfere. Although I have my certain reservations in fact that with highly unregulated the market being, the entire exchange of crypto market, and several from Bitcoin starting to wazirx, there are several platforms dealing with it. It may require a completely different regulatory framework, like how SEBI is a completely different framework for it to be regulated, because how technically intense the entire what is a gamut of cryptocurrencies. Like you really need supercomputers and you have to solve complex mathematical problems to actually mine cryptocurrency, which is limited. Means once a cryptocurrency is limited to say 10,000 cryptocurrencies, it can never be increased thereafter. Keeping that in mind, it is a completely different kind of what do you say valuable which can be exchanged. So probably the courts may interfere to the how highly technical this particular
Right, sir.
currency is. That's all.
Right. Right, and definitely, Shravanth, India's crypto landscape seems to have crossed a legal crucial threshold. We'll have to see how this space really develops further. And of course, this is an observation that's been made by the Madras High Court. But does it have an impact on how India sort of deals with regulation of cryptocurrency? And of course, as far as a law on cryptocurrency, as far as that is concerned, we'll have to wait and see. But for the moment, thank you very much for taking the time out and speaking to us here on ET Now.